Now that we know the actual procedural packet of documents that are needed to get to the court, the question is, what is it that we need to show the court in addition to all the facts and supporting documents, etc.? What law do we need to explain to the court to ensure that we can get that receiver? Similar to a TRO, a temporary restraining order for a preliminary injunction, we need to show that, number one, acknowledging that this remedy is extraordinary, we need to adhere to the standard of showing clear and convincing evidence that the receiver is needed. This scenario needs to show that there's some sort of sense of urgency. Number one, what do we need to really show? The first element is irreparable harm. We need to show that in the event we don't get some sort of injunction with the receiver appointed, that there's going to be irreparable harm to the company. Now, what is irreparable harm? Certainly, there's no one strict definition, but the general idea is that if we were to proceed to trial and obtain a judgment, and that judgment would be rendered worthless, the potential harm to the plaintiff is going to be considered irreparable. We also need to show a likelihood of success on the merits. Now, a likelihood of success on the merits doesn't mean we need to prove the case as if we're going to trial, but it does mean that we need to show the court that our claims are abundantly strong. So if we just go to the court and we say that, yeah, our claim for breach of contract, breach of fiduciary duty, we've got these claims, but we failed to provide proper evidence through documentary evidence to support why we need this receiver. If we can't show that we're likely to be successful on the breach of contract, the fiduciary breach claim, the fraud claim, guess what? Court's not going to grant a receivership. Beyond that, balancing of the equities. So the balancing of the equities is the third element we need to show, and we need to show that it actually weighs in favor of the plaintiff. And what that means is the court itself is going to weigh the potential harm to the plaintiff if the receiver is not appointed against the potential harm to the defendant or other interested parties if the receiver is appointed. Usually, if the plaintiff is moving for a receivership, the balancing of equities, if they've established certainly irreparable harm and a likelihood of success in the merits, the balancing of equities is most of the time going to be in favor of the plaintiff. So it's going to be a rare scenario where the balancing of equities would actually be in favor of the defendant if irreparable harm and a likelihood of success in the merits has already been established. The courts are very hesitant to just go ahead and grant injunctions and to go ahead and grant receiverships. And the reason is because they want, generally speaking, the status quo to be maintained. And we need to show that if this doesn't happen, the status quo of the business won't be maintained.